Evaluation of the evidence that at the end of the trial, it is therefore a sui generis interlocutory procedure. The test must be applied with judicial discretion on the facts and circumstances of each case. The compass on which this matter should be a combination of the first leg of the Shuping case and the dictum in the Lubatra case, and the principles of a fair trial in terms of the Constitution 96. The manner in which this discretion must be exercised has been considered in several decisions. It is evident that the presumption of It is evident that the presumption in favor of innocence, the fact that the onus rests on the state, as well as the dictates of justice, will normally require an under 174 in favor of the accused person, where the state case is virtually non-existent. Strengthening the case is in any event a physical impossibility. Finally, the court will refer to State versus Ndlanga Mandla and another 391 in brackets WAD bracket, where Willis J. considered the application in terms of section 174 and held that amongst other factors that credibility such poor quality that no reasonable person could possibly accept it should be taken into account at this stage. Followed in various matters that followed, including State versus Mtembu and others, 27 SICR 286, as well as in State versus Agliotti 2011 2 SICR 437 brackets GSJ bracket, and the local the constitutional implications, which was clarified in State versus Lubaka decision and citation already placed on record. Lastly, with regards to the various case laws, refer to the position in as far as it relates to an accused as well as it is the position in this case today. The trial court should discharge an accused who might be incriminated by a co-accused is not a question to be answered in the abstract, for the circumstances in which the question arises. The court once again refers to the matter of Ndlanga Mandla and another, where the accused right at the outset gave an explanation of plea, i.e. accused 2 denied the allegations and placed emphasis on the fact that he did not hand any between accused 1 and 2, as well as the content of their respective plea explanations clearly indicate that accused 1 incriminate one another in this matter. In this regard, the court also mentioned in the heads of argument on behalf of accused 2, which we will still deal with. Lastly, with regards to the credibility of the witnesses and the application of it was not always considered to be a relevant factor in the past. However, it has developed in the later years from not only being taken into account but also becoming a relevant factor. Was shared and expanded on in State versus Agliotti and also applied in State versus Diwani, CC 15/2014, and pronounced more explicitly in the Doorewaard case citation already on record. The court is given the power to the closure of the state case, a judgment of not guilty. There is, however, a jurisdiction before the power arises in this manner. the court must be of the view that there is no evidence upon which a conviction can be based. Therefore, two related but distinguishable decisions have to be made. Firstly, is there a lack of evidence, and if so, should discharge? The former entails mainly a clinical assessment of the evidential value of the evidence. The latter requires sound judgment in the light of circumstances of the particular case. There is no obligation to grant a discharge, but there is indeed a competence to do so. The state, including the defense for I've quoted cases as I've stated. I will now start off firstly by outlining the evidence presented by the state to court at this stage of argument raised. Okay. It is indeed so, as pointed out, 19 witnesses in this matter was called, and the state during its reply and the defense in its application had also read out all 6 counts or charges as far as to each accused. Therefore, there is really no need to repeat this, as they are already on record and was repeated in their heads of argument. The court will now proceed with the evidence presented by the state thus far. First, Nkwali was heard, who was appointed on the 4th of July 2018 as an authorized member of the upcoming EFF celebration Stadium on 28 July 2018. His duties entailed calling of security meetings, including representatives from the EFF itself. However, on the 28th of July, the EFF was meeting by one Mr. Dlamini. The duty of the witness was to ensure a safe and incident-free event. He testified that may be allowed except for those assigned as protectors for the leadership. Testified that after the event he was Nkoho on the now known, or according to the evidence of this witness, Mr. Malema, who started firing shots. He was also in a case in this regard, and further that only the EFF security was allowed to regulate who will be allowed on the